Welcome to My Money, Your Money, a talk show on generational wealth, wealth management, and personal finance. Now introducing our host, Miss Brigette Lumpkins.
Hello, beautiful people, and welcome to My Money, Your Money, brought to you by our generous sponsors, Demesman and Dover Accident Attorneys. I am your host, Brigette Lumpkins. I earned an MBA from Wharton and have worked at firms such as Goldman Sachs, Lehman Brothers, and Barclays, serving institutional and private clients and raising capital for investment funds. Currently, I'm an executive at a crypto asset management firm in Miami. Please join me in welcoming my guest, attorney Monique D. Hayes, who, in addition to practicing law full-time, runs a digital platform called Estates Made Easy to help people in the community to create life plans and identify resources to execute those plans. An alumna of the University of Miami Law School, she has been in practice for 17 years and is passionate about sharing her expertise with our community. Monique, welcome.
Thank you. Thank you so much for having me.
My pleasure. So please, I gave you a brief introduction there, but I'm sure I didn't do you justice. So can you fill in the blanks a little bit? Can you tell us a little bit more about yourself?
Sure. I'm a native Miamian. I'm passionate about all things sustainability for Miami and her residents, particularly for communities of color. I graduated from the University of South Florida, which was my undergraduate school, and then I returned to Miami for law school and have been here in Miami since. My practice as an attorney is primarily in the business sector, serving fiduciaries as well as business owners in corporate restructuring, business bankruptcy. But I also have a business. I'm a founder of a tech startup, and that startup is Estates Made Easy. And the mission of that startup is to bring generational wealth within reach for the middle class.
So when we were just chatting before the show, we talked about that word wealth a little bit, and how it relates to how people approach making a plan for their life long-term and after, and their heirs, et cetera. Can you talk about how you think about wealth and what that means when you say it?
Well, I think about legacy as the most important thing. So irrespective of the level of wealth that you have, we all have legacies that we intend to preserve and protect. And so we should have a plan to do that. Now, there are some people whose legacies are fragile and more important to be able to protect. And those primarily include homeowners and parents. And so for that category of people, it's critical that they have some type of life and legacy plan. I try not to use in common circles the term estate plan, because a lot of people get overwhelmed by that term and they think that it's inapplicable to their current situation. So what I try to explain to people and reinforce is that if you have a home or if you have children, you should have a plan in order to protect them. Then if you have any type of assets, and really that's just stuff, and we all have stuff, and those things have varying levels of value. But if you have things, stuff that you want to pass on, you should also have a plan to protect those.
And what does that mean, protect? Do you mean like protecting from the dilution of the assets post, by the tax man, after you're gone? What do you mean protect?
Well, so protection is in a broad sense, and really is to ensure that it passes to the person or entities that you would want to receive the benefit from it. So if you are a homeowner, then you want to pass along property to a family member, or to preserve that property for the benefit of a family member after you pass away, then there are ways to do that that makes it efficient and affordable, and ideally to avoid probate. So you protect it from, loss to spending money and having the value taken out by paying lawyers, but you also protect it from taxes, but you also need to protect it from third parties. So that, and that could include, the government, that could include creditors, that could include other persons that have intents that are different than yours. So you want to preserve and protect it so that it gets to the beneficiary, the person that you wanted and intended to have it in the best way possible. So that is generally what I think about when I say protect it, is really ensuring that your intent is honored and that third parties, and that could be creditors, that could be the government, that could be loss of value because you have to pay unnecessary legal fees through the probate system. That those are things that could be avoided in advance.
So you said the word probate a couple of times, and I think most of us have heard that word, but I think a lot of people don't know what it means. Can you explain what probate means?
Sure. So generally, and I'll try to give you some context. So generally, if you do absolutely no planning for your assets, and when I say assets, I mean your house, your car, your watch, the money's in your bank account. If you have no advanced planning, and you happen to pass away, then in order for your heirs, for your family members to gain access to your bank account or to gain access to title to the property that you left behind, including real estate, including a car, they would need to go to a specialty court in order to have a judge make the determination of who and how property should be transferred. And the type of specialty court is called a probate court.
Okay. How long does that
Sure.
process generally take?
It could take anywhere from 90 days to years.
Okay.
And it depends on the complexity of the case. And so it costs not only time, but it also costs money to go through the probate process. And so there are ways to avoid probate in advance. And that's by making a plan. And that's what I encourage everyone to do, regardless of the amount of your assets and the value, is to have a plan set in advance that will minimize the need to go to probate. And for sure, we don't even need to say the word probate. It's that we minimize the need to go to court in order to determine ownership of assets
that are left behind. Okay. So, we see a lot of people who, it's one thing, I think, for your average person who has, like, let's call it a $250,000 home that they owe $200,000 on, and a $10,000 car, and like $50,000 in the bank or whatever, and like $40,000 of debt, let's call it. Like, maybe that's like your typical sort of working class estate, and that person passes away. I would imagine it's not very uncommon for that person to not have like a will, et cetera. But we see people, because they think it's inaccessible, and I understand that's your mission, is to make this kind of planning accessible to those people. But we see people who had resources and complex financial lives and lots of money die all the time without plans in place, right?
Yeah, because it's irrespective of income level.
Right. It has nothing to do with that. So can you talk about
education?
Right, exactly. So we see people like, I think Prince died without proper documents in place, and that's the kind of probate process that I'm sure could take years. And then, of course, the bus driver, that bus driver profile maybe that I just outlined, right? Who has a wife and some kids, and now there's all this kinds of issues. So can you talk about the psychology behind people's resistance to plan, even beyond the idea that they don't understand it, or it's intimidating, or it's not accessible to them? Because I know that some people may think, oh, this lawyer wants to charge me $2,000 to do all of this stuff, and I don't have $2,000, so I'm not going to do it. But like, that's not the only reason why people don't plan. So can you talk a little bit about what you encounter as far as barriers to planning?
Sure. So generally, 60% of Americans don't have any type of estate plan, don't have any type of will, trust document that will help their family understand what their desires would have been and to execute on those desires. When it comes to the African American community, the Black community, it is 70%.
Wow.
And that's irrespective of income level. So you talk about people that are in the range of $80,000 to $150,000 income level, still don't have these types of estate plans. And there are a number of reasons why. Most people respond that they don't find it affordable, or they just haven't gotten around to doing it. So it's the time thing, but also there is a mental hurdle that people also have to overcome, because it's hard to even begin to think about your potential demise. People just generally think that they have time and they'll put it off.
Well, it's not a potential demise.
No.
It's not a potential demise.
It's the eventual. It's the eventual demise, and we don't. None of us know if we're going to be, 18, 21, or 95 at the time that we pass away. But it is lofty, and there are so many things that come into play: family dynamics, the complications within families, divorces, marriages, businesses. These things that become overwhelming, and they bog people down from even starting the process. So that is among the mental hurdles that people have to getting it done. So, but the primary objective is to make it accessible and affordable to be able to plan. Those are the things that will help people to get over the hurdles and get them to actually create plans.
Okay,
you mentioned. Sure.
So you're saying that, so part of you eliminate sort of the logistical, and I guess by doing that, somewhat of the cost. I'm sure that making it easier makes it probably a little cheaper too in some ways. Through your platform, do you work with people ever around the mental hurdles, or do you feel like that's out of scope for your website?
Well, that's why I do things like this. It's the educating part. It's helping people to understand the importance of doing the planning.
Okay.
And that varies according to, people's personal family dynamics, as well as their professional and business dynamics. So I'll give you an example. It may be a young CEO of a startup business. Okay. He may be 24 years old and he has a partner in that business. Now, they are just in the trenches and getting the business started and have not thought about estate planning, but it's incredibly important because particularly for business owners, if should you pass away, your interest in the business passes along to your next heir. Now, imagine if you're that business owner and you became partner with a friend that had the skills and the abilities to move forward with the business. But God forbid something happened and that friend passed away. Now you end up in business with their spouse or with their mother, who don't have any knowledge of the business, but now have a controlling say about the business, because at the forefront of setting up the business, there was no estate plan and there was no corresponding or consistent language in the business agreement that honored the estate plan.
Right.
And so you end up in business with someone that you never intended on being in business to, that may have no clue about how to run the business. Or maybe they say, well, I actually don't want to be in this business. I want you to buy me out. But you don't have
the money. It's not set up. Okay, so can you talk about what's
important to start the plan?
Okay, so what's a kit? So, all right, so we've got somebody past the mental hurdle. They're like, okay, I'm going to do this. Estates made easy. What's the basic set of documents that people need that are the essentials to form the sort of basic plan?
Sure. So everyone that is an adult should have a will. And a will just speaks to It's a document. It's just a simple document. You don't even need a lawyer to create a will. The will is a document. It's a legal document. It needs to be signed. It needs to be notarized. It needs to be witnessed in order to give full effect to it. Mm-hmm. But it's the document that says who gets what. Okay. And even if you don't think you have an estate, I've started to talk to people about digital assets. And making sure that they're protecting those digital assets. When I say digital assets, most people assume that we're thinking about cryptocurrency and Bitcoin or Ethereum or those types of digital assets. But digital assets also includes your social media accounts. It also includes your cloud accounts. Mm-hmm. I had the experience of explaining to a mom who had lost her very young son to a motorcycle accident. And for this mom, all she wanted was to access the pictures, the videos that you have in your phone, because nowadays no one prints pictures or have picture books. But to the mom, that's an asset. That's incredibly valuable memories of her son. But when she contacted the service provider for the phone company, she didn't have the password. She told them that her son had died. They shut down the account and she couldn't have access to it.
Wow.
He hadn't prepared any documents. So for a parent of an unexpected loss of a child, they don't really care about getting your house, getting your car. They want those memories. Those are digital assets that your family would love to have. But if you don't provide them with access to that, it won't be honored. And so even if you're a millennial,
I think Facebook allows you to designate a person to take over
your account. They do, but you have to make that designation in advance. And so that's part of a plan. But that's different from each entity or organization have different policy. Mm-hmm. So there are privacy concerns as well as ownership concerns. So through your will, you can designate or give a privacy release so that if you're talking to Android or Apple or any other service provider, that they would give your privacy release to pass on the documents, but also ownership so that your family would be able to access those types of things. But the greater point is that you should have some type of plan to pass those things on. But that also applies to bank accounts. So even if you had $5 or if you had $50,000 or $100,000, it also applies to Cash App. We have Cash App on our phone. We have, Robinhood, all of these investment accounts. People are talking about generational wealth. God forbid something happens to you. How would your family get access to those accounts? Mm-hmm. If you had not done a plan in advance, they would have to resort to the courts. They would have to spend significant time and money getting access to those things. And those are the worst possible time.
Yeah. Mm-hmm. My family has been through this with an unexpected death. And so everything you're saying resonates so profoundly. And it really is very burdensome for your family to have to wade through all of those things and and compounds the grief process when things go to the wrong person or to the wrong whatever. I mean, I have 30-something thousand photos in my cloud, right? And I know my aunties and them would want them. So, and then a fair amount of them are just bad selfies, but they probably want those too. So, you make an excellent point about the digital assets. And so is that covered by you designating options at the account level, or it's just covered by your will? And so you can present the will to the service provider and they should be able to honor that?
It should be both, and it should be mirrored. So ideally, if you have a plan, in an ideal world, you would have backup, a digital as well as a analog, a paper backup that will provide your family with instructions. So you would have your will, but then also just a simple piece of paper letting them know what the passwords are, what the accounts are. Now, and you would also think in advance, like what you want your family to have access to. You may want your family to have access to, your mom to have access for your Facebook account. You don't necessarily want them having access to your Tinder account. You may say, I want my best friend to go in and shut that down, or whatever your choice is. But the point is, make a plan in advance. And some people say, well, you know what? if I'm gone, I really don't care what happens. But if you have a legacy, you're not only planning for what your wishes are, you're thinking about providing comfort to your family during that critical time.
Right.
And so that's why it's important to plan, so that while your family is going through grief, they aren't also burdened by administrative bureaucracies and also shelling out, cash in order to get people to help them to resolve these issues.
Okay, so say your life is more complicated than your family realizes, and someone tries to contest the will, like maybe someone who claims paternity, or some other, like some spouse that they didn't know you had, from a wild weekend in Vegas, or a creditor that for a business venture. So, can wills be contested? And also, after you say that, I would like for you, because I understand this is like sometimes wills are a little less foolproof than some other kinds of structures, like maybe a trust, for example.
Mhm.
If you could, in your answer, sort of describe the different sets of documents that can make your plan more bulletproof and less contestable.
Sure. So as I mentioned before, a will is just a document that says who gets what. Now, but it's still just a piece of paper. So in order for it to be enforced, it has to go before the court. And the court will say, okay, that is the signature. Is that confirmed that that was the correct signature, that it was properly witnessed, and that what the directive that they were given can be honored. Okay. And people could contest that. But that's why you leave it. That's why you try to avoid or minimize the need to go to court at all. But you should have it as a backup. So everyone should have that baseline document. But in an ideal world, I would want you to do everything in advance so that your family would not have to ever rely on the courts to make that determination for you. So some of the other types of planning documents that you could have is a trust setup. So a trust is similar to a will in that it says who gets what amongst your assets, but it also can describe when and how the beneficiaries get the assets. And it also does not require a court order to give it effect. From the moment that you create the trust, the instructions that you provide in the trust take effect, so long as you fund the trust. Okay. So then there's no need to go to probate court. The trust then becomes an entity, but you can think of it like a pot. So in the trust, you create a pot and you pour whatever you want into that pot. If it's a living trust during your lifetime, you still have control over it, but then, and you're the beneficiary during your lifetime, but once you pass away, you designate who is going to be the beneficiary after you, and then you're able to give conditions. So for instance, if you have children and you want them to go to college and graduate from college, before they get access to the $250,000 life insurance policy that you want them to have, you would put the policy into the trust, and you would say, I would like my children to be the beneficiaries. The money in the trust would help them, but these are the conditions. They have to go to college. They have to, buy, if they get ready to buy a house, then I will give them this amount. If they, get married, then I will give them this amount. So you could have give instructions that honors not only the financial legacy, but also the principles and the priorities that you have for your family that you can do in a trust that you cannot do in a will. Okay.
Now, is there an asset level below which a trust is not a cost-effective tool to use to execute a plan?
Sure. And it's not so much of an asset level as it is the overall objective. Like, for instance, some people I'll talk about in the state of Florida, for an example. We're here in the state of Florida. If the objective is, okay, I have this piece of real estate. I want to pass it on to my son. I want to avoid probate. I want to minimize taxes. Okay, a trust is a vehicle that you can put the house into a trust, and that is a way to avoid probate. That's a way to pass it along.
Mm-hmm.
But because the trust, what it's going to cost more to create the trust, the type of document and the oversight, there may be alternatives that can get to that same specific result. The result is passing on, for example, the house and avoiding probate. You may do a simple document with a real estate lawyer that's called a Ladybird Deed that gives the exact same effect.
Okay.
With a Ladybird Deed, what you can do is designate who is the successor owner of your real estate, your property, after you pass away. The important piece of a Ladybird Deed is that you maintain ownership and control over the property during your lifetime.
Mm-hmm.
The successor does not take control. They do not take an interest until after you pass away. It's a very simple real estate document. Real estate lawyers can do it very quickly, very cheaply, and easily. And it does not require probate in order to pass along ownership. Okay. And so it will give the same thing that if someone came to me and said, well, I thought I needed to do a trust in order to avoid probate, depending on their circumstances and the types of assets, there may be more efficient ways to do that. And there may be other lawyers, not necessarily an estate planning lawyer, a real estate lawyer that's cheaper and more effective that could get that done. The point is to have a plan and look at your circumstances and see what's the most effective thing. Okay. One of the things that people often use that creates problems for them in the long run to get that same result is a quitclaim deed. And I try to discourage people from using quitclaim deeds, particularly if it's involving the elderly, without the advice of a very experienced lawyer, because for seniors, the transfer of property, when you use a quitclaim deed, you transfer title immediately. Mm-hmm. So that means that people say, oh, I'm going to put my daughter or put my son on the house, while I'm alive with a quitclaim deed so they don't have to go to probate. The problem is you're giving them ownership immediately. And if you are or may become dependent on government benefits like Medicare or Medicaid, the fact that you gave away an interest in your property could affect your ability to be eligible for those benefits. It could and so that's very important, and people don't realize those consequences. And the cost of healthcare is incredibly high in this country, and a lot of our seniors are spending their retirement dollars just on healthcare, when they could have planned in advance to avoid that. So that's one of the tools that people want to use to try to avoid that. And they also consult, with a lawyer. So that's one of the reasons why I'm creating a national lawyer referral service, so that lawyers can help people to not get into these problems and make these huge mistakes. The other thing that you don't want to do with a quitclaim deed is impair your homestead exemption here in the state of Florida for tax purposes, as well as creditor avoidance
protection. Yes.
Mm-hmm. And those quitclaim deeds can get people in trouble with that. And so really it's about education and making sure people know that the options that they have, and they choose the one that's most effective and affordable for them.
Right. So, there's a lot of nuance and complexity, and really these solutions should be tailored to the individual. So that's the goal of your site. How does it work? If I'm a user and I'm like, oh gosh, I got stuff. What are they going to do with my books? I need to go to Estates Made Easy and figure this out. What is my user experience once I get to your site?
Sure. So you would respond to a 5-minute questionnaire, and based on your responses to the questionnaire, it will propose particular estate planning documents for you and make those documents available for your purchase.
Okay.
Okay, and the platform is based on the algorithm, and it learns more not only about your income and your assets, but also about your culture, because that makes a difference in the way that we plan. For instance, if you're from the Caribbean, or if your family is from the Caribbean, you may have property or property rights back home in the Caribbean. And so it's going to ask you, if you say that you're Black, it's also going to ask you if you have Caribbean heritage, if you're from African national heritage, because those things make a difference with the way that you plan. Same thing if you say that you are, Jewish. For an example, you may have Holocaust survivor rights that you need to preserve and protect. And that algorithm that's built into our platform will learn about different cultures, and then will propose documents that are responsive not only to the dollars and cents, to your age, to your income, to your assets, but also to your culture and to what's appropriate for you. So that is how Estates Made Easy works.
That's amazing. So using machine learning and AI to sort of tailor solutions and recommendations. And so now it's sort of analyzed me. The AI has done its woo-woo thing, and it has its list of recommendations. Then what happens?
And then you'll be presented with documents that you can purchase. And it'll be a will, a trust, a guardianship document. If you're a parent, I speak to parents all of the time, because I always say this: your idea of who, God forbid, something happened to you, who would take care of your kids, may be totally different than your spouse's idea.
Yeah.
But if you guys have not talked about that, if you guys have not documented that, just having godparents, step up in the church and say that they're going to be the godparents, that's not legally binding. If you have not documented who is going to actually care for your children, that's the most important thing. I don't care if you own a house. If you have children, please make sure that the people that you truly trust and think are capable of actually caring for your children are properly identified to do that. So those are the types of things that you can purchase on the website. And then you would download the documents, you would gather your witnesses, gather your notary, complete and sign the documents, and then you would preserve them and protect them in a safe place. It would come with instructions on how, for instance, if you had a trust as part of the documents, it would come with instructions on how you should fund the trust. But if you are a senior, or if you are, say, for instance, a multimillionaire, and you put that into if you respond to that question, then it's going to recommend to you that you not use our website. The website is not for everyone. It's really designed for the middle class, for multi-millionaires, or for those planners, or for seniors above 65. My preference is that they work with a lawyer, because there are tax considerations and more nuances that I'm incredibly sensitive to, that it's worth it to work with and spend your time with a lawyer than to even rely on my documents. I'm wholly confident in the website and the platform and our algorithm, but the counseling that goes along with it, there are certain circumstances for certain people, their responses to the algorithm will tell them that you have a more complex situation. We recommend that you speak with a lawyer, and we make these lawyers available to you. If you speak Spanish, there'll be a Spanish-speaking lawyer. Or if you're from the Caribbean, there's a lawyer that will understand your culture and your priorities in order to plan and work with you to get the proper documents done for you.
Okay. Well, this has been really informative. I learned some things I didn't know, and I'm sure that our audience did too. And I hope they'll visit your website to get some help, and whether it's a set of documents or a referral to an attorney, but most importantly, that they'll start thinking about how important this is to their whole portfolio of documents and lists of things to do, that they should prioritize it. And there's really, if we learn anything the last couple of years, we learned that we can't take it for granted that things are going to that we have a whole lot of time, and it's a lot to leave in the hands of your family if you don't have a plan in place. So thanks for your mission. Thank you for joining us. And we will now have a special message from Mr. Eric Knowles president of the Miami-Dade Chamber of Commerce.
It's great to be here. Thank you for having me. It's an honor to be here with you, MIA Magazine. I just want to give kudos to Dexter and a team that's doing some amazing work, highlighting those in our community that are doing such great things. It is the Miami-Dade Chamber's Holiday Gala. It's the 16th annual gala. The Miami Dolphins are the title sponsor. Stephen M. Ross is our honorary chairman, and it will be held at Hard Rock Stadium this Saturday at 6 o'clock at Hard Rock, as I said. And, you know, it's a celebration of the year. It's been a rough couple of years for all of us. We're starting to come out and to live again. But this will be the first gala that we've had in person in a couple of years. Last year we did it virtually. So this year, again, as I said, we're at Hard Rock, and we're honoring some amazing folks. Actually, we're having what we call the Trailblazer Award. First time we're having that, and we're honoring Mr. Ross with that award. We have the Distinguished Service Award, in which Shalia Nelson will receive that. We have the Citizen of the Year. Mayor Daniela Levine Cava will be receiving that. And we have the David Fincher Young Achiever Award, in which Maya Passamore will receive that one. And then we have what we call the H.T. Smith Lifetime Achievement Award for all the great work that H.T. has done in our community. You know, he spearheaded the boycott back in the 80s when Mandela was slighted by our our local government. But anyway, I'm not going to get into that right now. But anyway, H.T. has been a trailblazer himself. And we have the H.T. Smith Lifetime Achievement Award, and that's being given to none other than Bill Talbert, who just recently retired from the Greater Miami Convention and Visitors Bureau after being there 30 years. So I would say that's a lifetime. And so we look forward to honoring Bill and all the others. But a special presentation that we're going to do is recognize and celebrate Thelma Gibson. It is her 95th birthday. It's her 95th birthday. It's an amazing milestone, and she's still at it. You know, she was co-founded the Thelma Gibson Health Initiative, and so we just thought it would be right to celebrate her. Her birthday is in December, and we will be there, so come out. But when I say come out, a lot of you have heard that tickets have been, you know, they're sold out. Sponsorship is sold out. But we do have what we created, we call the lounge experience. So you can purchase tickets for $150, and you can be a part of the overall experience. When the event begins, we will have a reception. Everybody will be in the reception. And then when the event begins, those sponsors that have tables will go to their tables. The lounge experience guests will stay in the lounge. We'll have monitors that you can watch the event on those monitors, and then we will serve dinner. Everyone will have an amazing dinner. And after the dinner, we will have a party. So we want you to come out. You know, you can go to www.m-dcc.org, or you can call the chamber at 305-751-8648, and you can purchase those lounge tickets. I'm telling you, a lot of folks are buying those tickets. So jump on it. It's going to be a great night. Folks are still calling. They wanted to buy tickets to the gala. Tickets are sold out in the main ballroom, but we do have the lounge experience. And, you know, I want to thank some of our sponsors, Baptist, Brightline, obviously the Miami Dolphins, MCO Construction, all of my board members, and I'm going to get in trouble because I'm forgetting, I don't have a list of all our sponsors, but please go to our website, www.m-dcc.org, events, and you'll see all of our sponsors. And I truly want to thank those sponsors for their support of this year's gala. And I look forward to seeing you on Saturday, this Saturday. No, I was going to say November. Today's the last day of November. So, and as I'm laughing. But anyway, thank you, Dexter. Thank you to the team for all the support that you do. See you on Saturday, December 4th. Love you.
Get your tickets to the lounge. Get your tickets to the lounge experience for the Miami-Dade Chamber of Commerce gala this Saturday. You know what, Monique? We had a question come in, and we really want to answer this for our viewers, which is, if a father dies and his will has an instruction that leaves the house to the oldest child and there are 2 other living children, are they entitled to a share of the home?
Well, if we're assuming that the father's will was properly executed, his signature was done, and that'll be honored by the court, then everyone has a right to do essentially what they want with their property. If you have children, you do not have to give your property to your children. They may be upset about it, but you have that right. They could contest the will, but provided that the will was done properly, meaning that it properly identified the father's wishes, it was signed by the father, it was witnessed, and ideally that it was also notarized, then the children, based on the will, would not have an entitlement to their property, to that property. The children that were left out. In the ideal world, you would want the will to be explicitly clear that it was the father's intent to leave his love and admiration for the 2 children that were not receiving the home, but specifically to leave the home to the 1 child that it was intended for, so that there is no doubt. But even based on the facts that you gave me, the will, assuming that is validly executed, the court would honor the wishes of the father, and there's no entitlement to overrule what someone desires to have happen to their assets. It's his house. He has a right to give it to who he wants to, and that would be it. But that, because it's a will rather than a trust, it will ultimately be for the court to say that the will be honored. So we have to go to probate court to honor that will, because remember, the will is still a piece of paper, and the judge will say, well, that's what he said, and that's his right, and I'm going to honor it and give an order. And that order would then allow for the county recorder's office to redo the deed into the name of the specific child that he left it to. Okay.
And you're saying a trust skips the court process, and if he provides the same instructions or similar instructions in a trust, it would just be automatic and it's less contestable?
Right, and deed over the property to the trust during his lifetime. Mm-hmm.
Putting in the pot.
In the pot, exactly.
And the house is in the pot.
Exactly.
Okay. All right.
The beneficiary, or the trust keeps it, and then who gets to manage it and live in it, for their lifetime.
Right. Well, thank you again for joining us. This has been really so informative, and I'm sure there's tons of questions. This isn't nearly enough time to delve deeply into this topic. It's quite complex, but you've really given us a great intro, and I hope people will go to your site, Estates Made Easy, and is it estatesmadeeasy.com?
Yes.
And do you have social media where you want people to follow you?
Yes, the exact same thing on LinkedIn, on Twitter, on Instagram, all Estates Made Easy.
Okay, great. Well, thanks again, Monique. It's been a pleasure having you. Please watch our other MIA Media Group shows. Mondays, The Business of Black Business at 1 p.m. with Jay Reynolds. Tuesday, My Money, Your Money at 7 p.m. with me, Brigette Lumpkins. Wednesday, Soul at 7 with Nikki Gellin. Thursdays, Lunch with Legacy Leaders at noon with Anne-Marie Sorrell, and Flavor of South Florida at 7 p.m. with the legendary Chef Irie. Thank you so much for joining us, and let's close that gap.